I'll start by introducing myself a little bit here. I'm Ryan Froman. As Don mentioned, I'm the chair of the Pennsylvania Board of Appeals. By way of background, I was educated at two of our finer Pennsylvania institutions, a law degree from University of Pittsburgh and an MBA from Carnegie Mellon. And I have worked in the private sector. I've worked for a law firm, and now I've worked in the public sector for quite a while and have about 20 years of experience in tax appeals. So I'm going to share a little bit of that expertise with you today to help you better assist and make sure you're getting the right information, make sure you have a full understanding of any type of constituent issue that you may be involved in related to tax appeals. So to kind of start by walking you through the agenda, we're going to level set. I realize some people may have a bit more experience with the tax appeals process or have interacted with the tax appeals process, but others may not have. So we're going to kind of do a Pennsylvania Tax Appeals 101, walk through some things that may be interesting for those policy folks, on the call, and just a general understanding of the tax appeals process in Pennsylvania. Then we're going to get into some details about the Board of Appeals, and then more specifically about how to specifically assist a constituent with filing an appeal using our online petition center. We'll wrap up with some appeal tips and best practices, and as I mentioned, I'll stay on for some questions at the end. So let's dive right into the content here with the sort of Tax Appeals 101 section. I actually, before we even get into appeals, I always like to start off with a quick discussion of the notices coming out of the Department of Revenue, because this is an area that can cause a little bit of confusion. But from a legal perspective, the only notice the department sends out that creates due process rights to enter into the appeal system is the notice of assessment. The Department of Revenue will send out a lot of other informational notices, which we'll discuss a bit in the next slide. But it's this notice of assessment, or sometimes what's referred to, it'll say notice of audit assessment, that actually grants appeal rights and starts to trigger the due process rights into the appeals process. So it's important to be able to distinguish what different notices do and what they mean. But specifically, this notice of assessment, it has very important legal significance for entering the appeal process. And I distinguish it from a couple other notices that I'll reference. The statement of account, very helpful. It tells taxpayers what was paid, are their accounts in balance, things like that. It's much more about the payments and credits on their account. Very helpful notice, but it does not grant appeal rights. Likewise, a billing notice is something that is sent out to taxpayers before an assessment would go out. It's indicating that the department may intend to assess in the future, but again, the billing notice is not an appealable document. Also, there are dunning letters, delinquency notices that go out after an assessment was sent out, and these likewise are their tools for collections. Usually after a taxpayer has not appealed an assessment, but so they're collection letters, collection notices, but they also do not contain appeal rights. So it's an important distinction legally to understand the departmental notices, and that notice of assessment is really the legal document that allows taxpayers to access their due process rights and enter into the Pennsylvania tax appeals process. So with that being said, I'm going to give you sort of the 20,000-foot overview of the Pennsylvania tax appeals process. There are four main levels, and they each have sort of their own roles, responsibilities, and distinctions that we'll discuss here today. But the first level of appeal, which we're going to spend most of our time on, is the Pennsylvania Board of Appeals. The numbers that are up here for fiscal 24-25, and in that time frame, the Board of Appeals received about 32,000 appeals, a little over 32,000 appeals involving $5.2 billion. We had in that time frame an average turnaround time of 65 days on those appeals. Obviously, and we'll discuss this a bit more later, some of those appeals are done faster than 65 days. Some, obviously, particularly more complex ones, will take longer than 65 days. But if a taxpayer disagrees with the decision of the Board of Appeals, they then are able to appeal to the Board of Finance and Revenue. The Board of Finance and Revenue is fully independent from the Department of Revenue and is housed under the Treasurer. They received about 2,758 appeals in the same fiscal year, involving about 844 million. And because of an added degree of formality in their process, there's sort of 30-day windows for taxpayers to respond, Commonwealth to respond. They have a bit longer average turnaround time, but their average turnaround time in that same fiscal year was about 182 days. Once you get to Commonwealth Court, about 510 appeals involving about $313 million were filed up in Commonwealth Court during fiscal 24-25, and they are usually it's a much more formal, lengthy process, can be 2 to 3 years in terms of formally resolving those court cases at Commonwealth Court. A handful of cases will go up to the Pennsylvania Supreme Court each year. And obviously those oftentimes get a lot of people's attention. And I will also say, though I don't usually include it in this slide, that obviously above the Pennsylvania Supreme Court, a taxpayer could choose to appeal to the U.S. Supreme Court. I generally keep it off the slide because it's rare when that happens. There was a case that attempted to appeal to the U.S. Supreme Court about a year ago. The U.S. Supreme Court declined to take up that issue. As you can imagine, the U.S. Supreme Court doesn't weigh in on that many Pennsylvania state tax issues. But in theory, at the top of this hierarchy of appeals is the Pennsylvania Supreme Court. I also like to kind of give a broader framework of this because I will certainly spend a lot more time on the Board of Appeals. And part of the reason for that is that, as you can see, when we're going through this almost sort of filtering system, from 32,000 down to 2,700 appeals from the Board of Appeals to the Board of Finance and Revenue, that means that on average, in this past fiscal year, the Board of Appeals resolved about 93% of the appeals that came to us, and they did not go any higher. Likewise, those 7% that went up to Board of Finance and Revenue, then only about somewhere between 1 to 2% actually percolate up to Commonwealth Court, and obviously a very minimal number up to the Pennsylvania Supreme Court. So certainly the Board of Appeals is handling the bulk of the appeals workload, and these numbers are actually from a legislative and constituent standpoint. The bulk of the appeals that we see from legislative offices are going to be in the PTRR and PIT realms, and in those instances, even fewer appeals percolate up beyond the Board of Appeals. So the vast majority of PTRR and PIT, well in excess of 95% of those appeals are addressed and resolved fully at the Board of Appeals level. So getting into the Board of Appeals, which because so many of those appeals are resolved at our level, we're going to spend the bulk of our time here. What does the Board of Appeals do? I've certainly spoken about the notion that the notice of assessment triggers appeal rights into the Board of Appeals, and so we certainly do review those actions, those notices of assessment taken by the department against taxpayers. There's another area that we also do. Well, those assessments probably represent 55-60% of our volume. We also do review requests for petitions for refund. This is a situation where a taxpayer filed a personal income tax return. They realized they made a mistake of some kind, and they underreported their unreimbursed business expenses or forgot to offset a gain with a loss, different things, and they want to request a refund on that PIT return. They have the due process right to file that petition for refund with the Board of Appeals. We'll talk about the details of jurisdictional matters in a little bit, but we also deal with a couple areas that you may or may not be familiar with. Obviously, I think a lot of legislative offices are aware that the Board of Appeals handles denials of property tax rent rebate applications, but we also handle denials of tax credits. We also handle denials of charitable exemptions. We will also deal with certain types of adjustments such as cigarette license revocations and lottery license revocation denials or revocations. As you're likely aware, the lottery is under the umbrella of the Department of Revenue. So basically any action that's taken by the Department of Revenue, it's going to have appeal rights to the Board of Appeals. And I always make the point that for all these actions and for taxpayers to access their due process rights, if they disagree with the determination of the department, there are never any filing fees at the Board of Appeals. This is the next couple of slides are going to be a little bit of analytics for those who are engaged a bit more in policy, and it also is something that my training at Carnegie Mellon has my mindset very data driven. So I'm going to drag you down that rabbit hole with me a little bit here on for a couple of slides, though I'll try and move quickly for those who aren't as focused on analytics as I am. This particular chart represents the largest 6 tax types that we have at the Board of Appeals, and I bring it up just to show some general trends that you may be able to infer, but just to sort of reiterate. Historically, if you went back to, let's say, 2016, The Board of Appeals received about 15,000 sales tax appeals. That's that sort of purple or lavender color at the top, out of about 30,000 appeals. So sales tax, if you walk back about a decade, represented, as much as half of what we did at the Board of Appeals. Whereas you see in the blue section, which represents personal income tax, we were closer to 7,200 appeals, or only about maybe 25% of appeals were personal income tax. Now, if you fast forward to the most recent year, we're seeing that almost switch, where personal income tax has become a much higher percentage of our work, and sales tax has declined. This certainly reflects some shifting focus of resources in terms of where the department is putting time and effort in terms of trying to make taxpayers compliant. There were a number of sales tax initiatives that went on in 2016, 2017, 2018, and some of those have resulted in much higher rates of compliance. So those are not as active anymore. I'll also say you can typically see some sort of macro trends in terms of the appeals we receive. For example, realty transfer tax will ebb and flow depending on, to generalize, if the real estate market is hot and there's lots of properties selling, we tend to then get more realty transfer tax appeals. If the real estate market is not as hot, there aren't as many transactions, we see fewer appeals in that area. We've certainly seen some more appeals with the expansion of property tax rent rebate in recent years in that area. And inheritance, tax, for example, will ebb and flow. We saw certainly a larger volume of appeals, let's say in 2021, with increased morbidity rates associated with COVID. And so there can be macro trends, and also, departmental selection of resources that can ebb and flow where we're seeing appeals at any given point in time. But we stay attuned to these trends and shift our resources appropriately to handle any increases or decreases in volume of appeals in certain targeted areas. I also like to point from a geographic standpoint on our analytics. We receive appeals from all 67 counties, though, as I imagine you would expect, we receive higher volumes of appeals in areas that have higher populations. That's not going to be a big surprise to anybody in particular. But I also like to make note here on the right with the national map that about 25% of the appeals we receive are from taxpayers located outside Pennsylvania. These are businesses, individuals who have business activities or have made investments, have income, maybe working, traveling in and out of Pennsylvania. They have some sort of taxable activity going on in Pennsylvania, and so about 25% of the appeals we receive are actually from those who are residing outside Pennsylvania, and on a given year, somewhere between 3 to 5% of our appeals are actually sourced internationally as well. This chart, which may be a little bit difficult to read depending on the size of your screen, I'll just sort of simplify this a little bit. It's showing sort of a downward trend. At both the lighter blue is the Board of Appeals turnaround time, the darker blue is the Board of Finance and Revenue turnaround time, and we're seeing in the past couple years a decline, somewhat notable, particularly with the Board of Appeals, in our turnaround times. We have sort of an internal mantra or bumper sticker almost that we say is the goal is to get the appeals resolved accurately and efficiently at the lowest level possible. And so there are a number of procedural things that we've improved, and we'll speak to some of those over time. But we had historically a turnaround time at the Board of Appeals closer to 100 days, and now we're down closer to 65 days, about a 35% reduction in our turnaround times over recent years, and we hope to see that continue to decrease moving forward. One sort of last slide from an analytics standpoint, I also like to point out that at the Board of Appeals, this slide represents those who have a tax professional representing themselves, which would be sort of the pink area, versus those taxpayers who are representing themselves in the purple area. So at the Board of Appeals level, about 65% of taxpayers are representing themselves. They don't have a tax professional handling or assisting their appeal. And one of the things that I use this to speak to is the notion that the Board of Appeals has a little bit of a challenging mandate, because on the one hand, we receive very sophisticated appeals from Fortune 500 companies on very technical and challenging legal issues. But on the other hand, we receive appeals from, somebody's grandmother who doesn't understand why she was denied a property tax rent rebate, and certain situations may require, very detailed processes, procedures, and certain situations may require a little additional hand holding for the taxpayers. And so our team always strives to balance those needs and the needs of the people that we serve. I also use this slide to make note that the Department of Revenue recently, starting about 2 years ago now, started partnerships with low-income tax clinics. And this has been a very successful initiative. I would encourage you to take a look at it at revenue.pa.gov/LITC. But basically, for low-income taxpayers throughout Pennsylvania, there are low-income tax clinics who will provide free representation to taxpayers going through the tax appeals process. Certainly, it's something that many of your offices may find a valuable tool to interact with those low-income tax clinics, build relationships on areas where your offices may not be as comfortable, these partnerships have really allowed Pennsylvania to go from an area where we weren't providing, to be honest, we weren't providing any support for those low-income tax clinics, to now Pennsylvania has become a model over the past 2 years. We have states across the country coming to us saying, how did you improve your interactions with the low-income tax clinics so much? And so we're actually getting asked to speak quite frequently on the success of that low-income tax clinic initiative and partnership with the Department of Revenue. So certainly want to draw your attention to that, because there are quite a number of taxpayers who are going through the appeals process and may need assistance along the way, whether it be through legislative offices or through these low-income tax clinics. So I also want to, in terms of providing assistance to taxpayers, I want to make note that the Board of Appeals on our website is really trying to make efforts to reach out to those taxpayers and provide them with content that's easy to understand. We have a number of instructional videos on our website that walk through just the Board of Appeals process in general, our e-petition filing process, understanding compromises at the Board of Appeals, which we'll talk about a little bit. We also partnered with the Department of Labor and Industry to produce the Department of Revenue's first American Sign Language videos. So those are available in American Sign Language. And from a general accessibility standpoint, I would also make note that the platform that we use for these videos is also available to be converted into over 100 different languages. So I'm sure there have been occasions where there may be language barriers. You may interact with people who have English as a second language coming into your office, or those who may be deaf, hard of hearing. These are tools that you can use to try and have the constituent understand the appeals process and what they're encountering, and the platform will help you put it in a language where they may be more comfortable. So that being said, I'm also going to indicate, as we get more into some of the detailed content, I will say that we're going to speak to some of these, but these videos may be just a good overview. There's only so much I can cover during the course of this presentation, so you may want to go back on your own just for informational purposes and click through these videos to get a better sense of some different areas of the appeals process and the Board of Appeals process that I may not have time to cover as in depth as I would like today. That being said, we're going to transition to jurisdiction. This is the one slide where I say I'm going to try and scare everybody a little bit, because jurisdiction is an area that we don't have a lot of flexibility here. The courts, when cases have gone up the chain, all the way up to the Pennsylvania Supreme Court, if a case is filed 2 years late or 2 months late or 2 days late or 2 minutes late, it's late. The courts have been extremely clear about this, and we don't have flexibility in this area. And so as a general rule, and we'll get into some nuances here, as a general rule, if a taxpayer receives an assessment, they have 60 days to file an appeal of that assessment. The one area where that has changed recently, and I thank and compliment the legislature on this, is Act 123 of 2024 extended the deadline from 60 days to 90 days for what we call Article 3 tax types. This is most notably personal income tax, but also includes employer withholding and pass-through entity taxes. So while the general rule for most tax types, your corporate net income taxes, your sales tax, your inheritance tax, remains 60 days, particularly for personal income tax, it's important to note that that deadline has now been extended to 90 days. I also want to make note of the petition for refund jurisdictional time frame, which is generally 3 years from when the taxpayer paid the tax. So the general rule is if they filed a 2021 return in 2022, and on April 15th of 2022, they file and pay that return. They're going to have 3 years until April 15th of 2025 to have filed that petition for refund. And if they're beyond that statute, their appeal won't be able to be heard. There's one other provision I want to make note of here, and it's what I kind of refer to as a little bit of a safe harbor provision for taxpayers to still have access to their due process rights. Because the question comes up a lot of times saying, okay, well, what happens if the taxpayer comes to the legislative office on day 61 or day 91, as it may be? What is their option? What can they do at that point in time? So they can't file a petition for reassessment, but the statute does have a provision embedded in it that allows them to pay the assessment, to pay the full tax penalty and interest, and that opens up a new 6-month window for them to file an appeal from 6 months from the date of actual payment. Again, they have to file and pay, pay the full face amount of the assessment, which is the tax penalty interest. This can be a little bit a little bit of a tough pill for taxpayers to swallow, in that if they think they don't owe it, that they may want to say, why do I have to pay to then, to get the money back? But in reality, this is, speaking a little bit more transparently with the legislature, this is also about the legislature's right to have certainty in terms of budgeting and money, and not just have open-ended statutes, so that you can have certainty for budgeting purposes about what funds the Commonwealth does have. So a lot of the statutes and statute of limitations are embedded in allowing the legislature to have more certainty, more fiscal certainty with the Commonwealth's finances as well. Getting into the Board of Appeals process a little bit, I want to just briefly discuss the Board of Appeals hearings. The Board of Appeals is a non-adversarial board. So if you picture, your typical courtroom drama, you have the prosecutor and the defense, and they're sitting on different tables, and they're going back and forth and arguing against each other. That is not the Board of Appeals. The Board of Appeals is a non-adversarial process. When we conduct a hearing, it's going to be conducted via Microsoft Teams. We have a particularly secure Microsoft Teams digital platform that allows us to discuss confidential taxpayer information across that. It's the equivalent that gets used by Homeland Security, Department of Defense to protect taxpayers' confidential information. If they want a hearing, they will have written notice sent to them about this. And one thing I'll make note about is that the hearings at the Board of Appeals remain fully confidential. The hearings, the decisions, everything is fully confidential. And I make note of that, and we'll discuss some distinctions with higher levels of appeal later. But once you get into the higher levels of appeal, hearings are in public forums, decisions are made public. So the Board of Appeals is the last level in which the taxpayers, and this is sort of a feature of the appeal system, not a an aberration or anything like that, but it's done as a feature. But this is the last level that everything remains fully confidential from a taxpayer's tax standpoint. The one other thing I just want to touch on here briefly is that a lot of times you may get questions: should I request a hearing? Should I not request a hearing? And at the end of the day, probably about 55 to 60% of our appeals are resolved without the need for a hearing. The way I suggest taxpayers to think about it: one, if they want a hearing, we will certainly conduct the hearing. The hearing does add a little extra turnaround time, typically maybe another 3 to 4 weeks in terms of turnaround time on cases, to get that scheduled for a mutually agreeable date and things like that. But if it's really a case about documentation, the taxpayer knows that they forgot to submit such and such form, and they just need to get us that form. Those type of documentation cases, there's not a lot of benefit that comes from a hearing. We're happy to grant the taxpayer hearing if they want to have the opportunity to be heard. But again, the majority of our cases are resolved without the need for a hearing. So just keep that in mind if taxpayers or constituents are asking about, should I request a hearing? Finally, the decision and order is sort of our work product, our end result. And our decisions are done in accordance with law, which I'll ask you to put a pin on that because I'll make a distinction with higher levels of appeal in just a moment. I also want to manage taxpayer expectations with regard to this because I've talked about that 65-day turnaround time. That being said, from a statutory standpoint, the Board of Appeals has 6 months from the date of the filing to issue the decision, and it's potentially even extended an additional 6 months if the taxpayer consents to that additional extension. Now, certainly, the vast majority of our cases are resolved within that 6 month window. As you can imagine, some more complex cases can take a little bit longer. And to be honest, the 6 month that extension of the 6 month is usually done more at the request of the taxpayer. There can be very complicated sales tax cases that may involve 30, 40, 50,000 transactions, and whether those transactions were taxable or not, and those need to be reviewed. Taxpayers need to pull together a lot of information, a lot of documentation, and we're happy to accommodate those requests for extended time period for taxpayers to try and satisfy their burden of proof. We do have a reconsideration provision, though this is highly limited. This reconsideration provision, I would say, is not an opportunity for taxpayers to relitigate an argument, but if we do make a simple mistake, we are humans, and if we make a simple mistake, like taxpayer was supposed to get a $650 refund and we had a typo and it says 560, we transposed two numbers, we will be happy to reopen and correct that. The Board of Appeals also does have compromise authority, which I want to touch on here briefly. The compromise authority exists if there is doubt as to liability or if it would promote effective tax administration. And if we agree to a compromise, that waives appeal rights. It resolves the matter fully for the Commonwealth and for the taxpayer. It's a one-page form that we have. You can see that form there on the left. And we have some instructions. I'll also make note that on our instructions, we've increasingly started to put little QR codes on them that link to video versions of the instructions as well. So that's been a helpful tool. Taxpayers have liked sort of interacting with the video versions of instructions as opposed to just reading the instructions on. But the compromise form is a one-page, fairly simple form. I will say that we don't compromise certain things that are the all or nothing category. For example, you qualify for the property tax rem rebate or you don't. Your sales tax is either revoked or not revoked. You're either a charity or not. You can't be 60% of a charity. So there's all or nothing situations aren't particularly appropriate for compromise. Also, a couple other situations, if a taxpayer is coming in and asking for 100% relief, that by definition is not a compromise. So that would be a non-starter. If taxpayers have significant non-filed returns or pending criminal prosecutions, those will be non-starters for compromises. And I also like to delineate here the notion that the Board of Appeals does not handle financial hardship compromises. The Board of Appeals, as I mentioned, we're dealing with those situations where there's doubt as to the liability. So the taxpayer thinks they owe $2,000 and the department thinks they owe $10,000 and we figure it out somewhere in between. If the taxpayer says, listen, I know I owe $10,000, there's no doubt about it, I just don't have the ability to pay, that's a collections matter, and within the department there's separate collections and compliance folks who deal with hardship compromises and analyze the taxpayer's financial position and their ability to pay. So those are not appropriate for the Board of Appeals, but the department does have other tools to help resolve those matters as well. And I like to make note that this compromise process has been very successful. Over the past decade or so, when we've had this compromise authority, we've granted over $1 billion worth of relief via this compromise process. And as you can see, based on the data on the right, we're usually somewhere in the 80 to 90% range in regard to taxpayers who present a compromise, who reach an agreeable compromise. This is not to say that we're giving 80% relief to taxpayers on that. It just means that, whether the taxpayer thought they wanted 25% relief or 50% relief or some sort of, dollar amount relief, there are a lot of ways we can structure these as they may make sense in a given situation. But in the vast majority, 80 to 90% of a taxpayer approaches us about a compromise, we are generally coming out with a workable compromise at the end of the process. I also make note that if taxpayers want to give us feedback, I did this with a bit of hesitation, but we put out a BOA survey with every decision. I'll jokingly say we get a lot of in fairness, I was a little concerned at first. I was wondering, are we going to get good feedback, constructive feedback? And about 75 to 80% of the feedback comes back extremely positive, which was very nice to hear, and we get a lot of compliments through this. There's about another 20% that may say, well, we want to raise this or that, and it's very constructive in nature. And I'll jokingly say, a single digits, 3 or 4% are people who write in all caps letters and are kind of using it as an inexpensive form of therapy. Those are less constructive, obviously, but we've been pleased that we've been able to provide this opportunity for feedback, and it's there's been a lot of actionable things that have come from it. So again, if your constituents do want to give us feedback at the end of the process, we certainly welcome that. I want to, before I get into the details of filing the appeal itself, I want to just sort of make note here of some distinctions between the Board of Appeals, where I spend most of my time there, and Board of Finance and Revenue and Commonwealth Court. As we discussed, they are the second and then third levels of appeal. Earlier, I made reference to the notion that the Board of Appeals issues decisions in accordance with law. The Board of Finance and Revenue has broader discretion than the Board of Appeals. They can issue decisions in accordance with law and equity. And so that equity component, that broader authority that they have, oftentimes allows them to be a little bit more receptive in situations, what I'll typically call like your form versus substance type scenarios, where as a matter of law, the department was correct and the Board of Appeals properly denied the taxpayer. But the Board of Finance and Revenue may be able to kind of look at the substance of what was going on a little bit and say, you know what, in fairness, the taxpayer, the substance of what they were trying to do was a little bit more, or merits some degree of relief. So they do have that broader authority. And you'll see in the tax appeals process, the Board of Appeals probably has the most limited authority, the Board of Finance a little bit more, Finance and Revenue a little bit more, Commonwealth Court and the Pennsylvania Supreme Court obviously have even broader authority than that in their decision making. I will say that I mentioned earlier the Board of Appeals has about 65% of taxpayers representing themselves. At the Board of Finance and Revenue, they are a more formal and now adversarial process, and as a result, over 2/3, about 68% of taxpayers are choosing to have a tax professional represent them at the Board of Finance and Revenue. As I mentioned, the Board of Appeals is not that adversarial process. However, when you get to the Board of Finance and Revenue, now you do have that adversarial process where you have an attorney from the Office of Chief Counsel representing the Commonwealth's interest in this, and they will make their arguments and try and defend the Commonwealth's position, and the taxpayer will need to likewise make their arguments, and the Board of Finance and Revenue will rule as to what they feel is the appropriate outcome of those cases. But there are also no ex parte communications. This is for anyone who's not familiar with this. The judge needs to talk to both parties at the same time. They can't just have sort of side conversations with one party or another. And so as you see there, you're starting as you get to the Board of Finance and Revenue. Now you're getting a little bit more formal in the process. Their hearings are also, as I mentioned, their hearings are public and their decisions are published on their website. If you ever want to go and see what a Board of Finance and Revenue hearing looks like or what their decision may look like, it's there's searchable databases of their decision on their website, and you can link to the videos of their hearings. Once you get to Commonwealth Court, then if you disagree with the Board of Finance and Revenue, you can you're now into the formal rules of appellate procedure. You need you can represent yourself, but the vast majority are represented by an attorney, and those cases are then handled, as opposed to Office of Chief Counsel, those cases are handled by the tax litigation section of the Office of the Attorney General. And likewise, if a case goes up to the Pennsylvania Supreme Court, that likewise would be handled by the Office of the Attorney General. So let's dive into the process of filing an appeal now, and start going down this path. And I will let you know in advance that we're not going to go through every single step of this. We're going to hit some highlights, and so obviously we'll there may be questions afterwards and we can talk through those. But to start with, there's only two ways to file an appeal, and one is the Board of Appeals Online Petition Center, which is found at revenue.pa.gov/tax-appeals. This was a new online petition. We've had a petition center for 25 years. The last one was around for quite a while. It was overdue for an update, and so we launched in early 2025 a new version of this. It's certainly more secure, more user-friendly. As I mentioned on that that feedback screen. We've been getting hanging out around a 4.7, 4.8 stars out of 5, which is probably a little bit better than than some of the Amazon products that I bought for holiday presents here recently. So we're pleased that we're getting very positive feedback from the users with regard to the online petition center. The other alternative way is by mail. Obviously, I know from a legislative standpoint, there have been some things that had been percolating through the legislative office, and I'm going to touch on why it's going to be a better decision for legislative offices to move towards using the online petition center here moving forward. Aside from the notion that those are the two legal ways to file an appeal, one thing I will start with is the new online petition center is simply easier and faster. If you're filling out the paper form, that form in itself is designed for all tax types. It kind of has to be, because it has to be for everyone and all tax types. It's not exactly perfect for anyone, and so there are a lot of fields that you need to know to leave blank, and there can be confusion and a lot of nuances in the on the paper form that taxpayers may be used to submitting. The online petition center adapts as you go along. So picture more of like a TurboTax type situation where it asks you a question first, and then because of that, it adapts. It's early on, it's asking you, what type of appeal are you filing? Are you filing a personal income tax appeal? And if so, it'll start asking you for your first name, middle name, last name. If you're filing a corporate tax appeal, it'll start asking for your business name. And it adapts to only ask you the questions and for the pieces of information that you need, or that we need to complete the appeal. So at the end of the day, filing the appeal using the online petition center is both easier, less confusing, and faster. Also, we are able to decide the appeal faster. There's less data entry, fewer issues with regard to appeals coming through there. So on average, an appeal that comes in through the online petition center is decided about 14 days faster than an appeal that comes in via paper or other methods in the past. So the online petition center has helped us improve our processing, and so to help better serve your constituents, it's certainly an added benefit to file using the online petition center. I would say we've enhanced the help tools on every page so that they're customized, very specific for what page the taxpayer may be on. Also, the taxpayer data is more secure. And in this day and age, nobody wants to be involved in a situation where somehow data got compromised, and the online petition center represents the best, most current, most up-to-date security protocols. And so we certainly, from the security of your constituents' tax information, we encourage you to use this as the most secure method to transfer confidential taxpayer information to us. When the taxpayer files the appeal, they'll get a confirmation number with a date timestamp, which allows them to know that, yes, the Board of Appeals absolutely has this, and I can rely on this confirmation number with a date timestamp. The new online petition center also has a petition tracker. So the taxpayer themselves or a legislative office can go in and check the status of the appeal 24/7 without having to contact the legislative office, contact the Board of Appeals to ask, via email or phone, and trying to ask and wait for a response on that. And there are lots of things that are designed to avoid errors and miscommunications, things like, address confirmations. Certain fields require certain numbers of digits so that, there's not typos, or minimizing typos and things like that in the online petition center. So at the end of the day, using the online petition center, there are certainly benefits to the Board of Appeals. There's certainly going to be significant benefits to the legislative office, but at the end of the day, it's really the biggest benefit is to the constituents. So in terms of providing the most effective service possible to your constituents, the online petition center is going to be the way that you're going to primarily want to file appeals. That being said, this is just a glimpse into the paper form. As I mentioned, it has to be sort of everything to everybody, but at its core, it's asking for petitioner information, tax type information, tax periods, some basic identification numbers, arguments and relief that is requested, and whether they want a hearing. But transitioning back to this, I want to start introducing you to the, what you'll run into if you go to revenue.pa.gov/tax appeals, which is sort of the starting point for filing an appeal. The page that you're seeing here is our general web page. Obviously, there's lots of easy to access frequently asked questions. There's links to all our video tutorials. There's links to all of our forms and publications. There's also some for if attorneys or CPAs have information or questions. There's some tax technical guidance for tax professionals on there. We certainly gear this website and the content much more towards a non-sophisticated, not towards tax professionals, but towards your everyday taxpayer. But there's obviously some technical guidance that we provide on that website as well for tax professionals. So in terms of walking through, taxpayer is going to have to both register, set up a Keystone login, and then they're going to need to, once they have that Keystone login set up, they will file their appeal using the online petition center. I'm not going to do a full step-by-step. I'm not going to make you watch me fill a name into the name, first name and another name into the last name. But I want to let you know that with these videos here, with registering for the Keystone login and Board of Appeals e-petition, do have those step-by-step walkthroughs that you can go back and look at for purposes of conserving your time today. I'm not going to have you go through all those steps today, but instead in the next couple of slides, I'm going to hit a couple highlights with regard to both the Keystone login and the online petition center. The Keystone login, I'm sure many of you are familiar with it at this point in time. The Keystone login has become along with other Commonwealth agencies, a very commonly used login. I believe it's used at Labor and Industry, it's used at state, it's used at health, it's used in a variety of different places. So I would imagine the majority of folks on this call may be already familiar with Keystone login. The one thing that, and I guess let me finish with not derail my train of thought on this, but the Keystone login is obviously much more secure, provides that multi-factor authentication that we want, and it's no more different. It's not different than anybody setting up an account for any commercial retail or anything like that. You basically create a username, a password, add a couple of security questions, and confirm your email address either via the email or via a text message. Quick tip on this, just so you're aware in advance, that when you're setting up a Keystone login, that the password has to be 12 to 128 characters. You can't use a username, a first name or a last name involved in that. You need one uppercase, one lowercase, one numeric, and one special character. Those are all things I'm sure the vast majority of you have seen when you're setting up a username and a password on almost any site these days. And the other thing I want to just touch on here briefly is that in theory, and this is going to be a conversation for that we can certainly continue, but what I would encourage legislative offices to do as a best practice, if a constituent comes in and they want assistance, they kind of want you to hold their hand walking through this process, set up a Keystone login for them. In theory, there's the technical capability to set up a Keystone login for your office. But what I would suggest is a best practice, and you can certainly speak with your caucus administrators with regard to this. From my perspective, the best practice, for a variety of reasons that we'll touch on, is to set that up for the taxpayer, because the taxpayer then can also access other Commonwealth services, so you're helping them even beyond the tax appeals process. But again, there's also we're going to want to delineate the notion of the legislative office is assisting in the filing of an appeal, but is not serving as the taxpayer's attorney or their CPA or something like that. So at the end of the day, the best practice with regard to this is to assist the taxpayer in setting up their own Keystone login. And then if you need to check on statuses of things at any point in time, you can always, the taxpayer can check on them, but you can also always reach out to the legislative office as well. They'll be there to support you as they always have been. So getting to know the online petition center a little bit here, when you first get to it, obviously you'll have a very clean looking front page here, which you can see a snippet of. The second page of it is going to be sort of informational and legal disclosures that we're required to put into there. I've highlighted the taskbar, the menu bar here along the left side, which just has a few basic things like starting a new petition. That petition search feature is your petition tracker. Anything if you need to adjust a Keystone login user profile, and a couple basic forms that taxpayers may need, or access to all our forms. I will make a quick note here that the online petition center is going through an upgrade. We certainly have been aiming to be very accessible, and the online petition center was originally designed to be WCAG 2.1 compliant. New standards have come out with regard to ADA compliance, and there's now the WCAG 2.2 standard, and so we're in the process of becoming one of the early Commonwealth portals to now meet that higher standard in terms of accessibility and ADA compliance. There will be a few changes that assist things like vision vision readers or screen readers for people with vision challenges. The main thing I'll say from a style standpoint, this taskbar, which is sort of along the left-hand side, going vertically on the left-hand side, will now be shifted to go horizontally across the top. So again, it's going to be the same content, but a couple of things in 2026 may start to look visually just a touch different, but the substance is still very much the same. We're just trying to accommodate those WCAG 2.2 accessibility standards as we move into 2026. This slide kind of deals with the bulk of the substance of what a taxpayer needs to provide. As you'll see across the top bar here, there's a section 1, 2, 3, 4, 5, 6. Those are the core sections where you'll be providing the tax type, tax period, the petitioner type, whether they're an individual, whether they're a corporation, whether they're an estate of trust. We'll talk about this part 3, the representative information in more detail in the next slide. But basically, I don't want to intimidate you too much, because these aren't like, this doesn't turn our form into like 6 full pages of things that need to be filled out. A lot of these sections are one question. Do you want a hearing or do you not want a hearing? Where do we send the correspondence? Do we send it via email? Do we send it via U.S. mail back to you? Things like that. So a lot of these sections are very quick to peruse. We've just sort of set them up in those different blocks where you would click next on them, and so that you can move through them quickly, and that it can be dynamic and change the fields so that you're only answering the questions that we need you to answer on these. So I want to pause. I'll just go back to the top again. That sort of section 3 where I talked about representative information. We're going to have a quick discussion here about special features that we've designed entirely for the Pennsylvania legislature and for those involved in constituent services. First, it's going to be important to start with the notion that when we use the term representative, it's easy to confuse it with this audience. Understandably, representative for a lot of you may generally refer to a member of the House of Representatives, an elected official in the General Assembly. But when you're talking about tax appeals and walking through the judicial process associated with tax appeals, a representative is referring to a tax attorney, a CPA, somebody who is legally representing and has professional responsibility for a specific taxpayer. And in the instances of the legislative office, we want to give you the option to facilitate the submission of the appeal, but we also don't want you to be legally on the hook or responsible for the actions of the taxpayer and what they may be doing. So we set up this special feature where on this page, you'll have the opportunity to check a box, yes or no. Are you a state legislator or an employee of a state legislator assisting with the filing of an appeal on behalf of a constituent? And if you check yes, that will allow you to enter the legislator's name, district number, the employee or staffer name, phone number, email address. And by entering this will allow that information not only be transmitted to the Board of Appeals, but our legislative office will know about that information, and at the end of the day, we'll be able to provide that appeal with the appropriate degree of prioritization and hand-holding and treatment that you've come to expect out of appeals that have come through the legislative office. It'll also allow the legislative office to know exactly what's going on at any point in time, so you can always continue to reach out to the legislative office while you'll be filing the appeal using the online petition center. You can certainly and obviously continue engaging with the legislative office, and I'll allow them to continue to communicate about how best to do that. But I wanted to make particular note of this because there has been some confusion over the years that the term representative does not mean House of Representatives. It does not mean it's somebody who represents their constituents. A representative in this context means that attorney or CPA, which is not going to be a legislative, constituent service, role in a legislator's office. So we have this special feature for you, we'll I just sort of wanted to highlight that, particularly with this audience. That being said, the final step here is the summary and certification. The summary page is what you would expect anytime you place an order online. You say, hey, this is my order. Is this all correct? It's going to provide a summary of everything that has been provided, all the information that's been provided, give the taxpayer an opportunity to say, yep, this all looks good, and you hit next. And then the final page is the electronic signature and certification. Once the taxpayer electronically signs it, they will be given that confirmation number that I told you about. The confirmation number will come with a date timestamp on it. And in fairness, the confirmation number, just as a little insider thing, is also going to have a little bit of a timestamp in there. You see on this particular one, it's 2025, 12/14. Basically, the confirmation number starts with the date that the appeal was submitted as well, and then has a unique number added onto that. Just a little insider IT information there. So I'm going to transition into some tips for success here, just a couple additional slides, and then I'll open it up to questions. One thing I want to make note of, and many of you may be well versed in this, certainly it was a very important, and I very much thank the legislature for Act 123 of 2024, which was a standalone bill that created a number of improvements to the tax appeals process. The effective date was early in 2025, so we've been implementing these changes throughout this past year. As I mentioned earlier, the time frame to appeal mostly Article 3 taxes, which is mostly PIT, but also in employer withholding and pass-through entity taxes. That time frame is changed to 90 days. And I'll also note there's a little window for us. If there's some special cause, we can perhaps even extend it an additional 30 days. Well, all the other tax types, corp tax, sales tax, things like that, remain 60 days. I will let you know that change in that statute now has made Pennsylvania the most taxpayer-friendly state in the country with regard to appeal timeframes. Most states are around that 60-day time frame. There are a lot of states that may be 30 or 45 days. Pennsylvania currently has the most taxpayer-friendly statute in terms of time frame to file a petition for reassessment in these personal income tax contexts. So that I think was a very taxpayer-friendly adjustment that came out of Act 123. Another one that I want to make note of was another taxpayer-friendly adjustment was historically the statute said that if a taxpayer filed an appeal via mail and they took it to the U.S. Postal Service, that was viewed as the government receiving it. So we could use the postmark date as the date the appeal was received. However, if the taxpayer, they may have, thought they were being good about this and went to FedEx or UPS and tried to send it somehow express, those third-party carriers, we could not view that as the equivalent of the government receiving the appeal under the statute. And so basically we'd have to use the date that the Board of Appeals received the appeal from FedEx or UPS. And this caused not a ton of problems, but from time to time it would cause some confusion, and taxpayers would miss out on their appeal deadlines or be late because of this confusion. And Act 123 made the taxpayer-friendly adjustment to make those other third-party carriers like FedEx, UPS, DHL designated delivery services, and we can use the postmark date or the tracking information from FedEx to determine that the day that they gave it to FedEx is the day that it's effectively filed. So that was another taxpayer-friendly adjustment made by the legislature in Act 123. And one other thing I just want to touch on a little bit was that Act 123 has added a new mediated settlement provision, where if a taxpayer is trying to compromise a tax liability, compromise procedure still exists at the Board of Appeals, at the Board of Finance and Revenue. And in that situation, it's basically the taxpayer and, let's say at the Board of Finance or the taxpayer and the attorney for the Commonwealth having a discussion and seeing if they can reach an agreeable compromise. The mediated settlement provision is a side provision or an adjacent provision to that that says in some situations it may be helpful to put a third party mediator in the room between the taxpayer and the counsel for the Commonwealth. This is a provision that only exists at the Board of Finance and Revenue. That's not a provision they can request at the Board of Appeals. It's sort of a pilot thing that the Board of Finance and Revenue has wanted to try. I commend them for looking for new and different ways to try and bring matters to a resolution accurately and efficiently at the lowest level possible. And we'll see how that program continues to develop. But I at least wanted to make you aware that provision exists, but it does exist only at the BF&R level. I'm going to add one quick note here about tax fraud because I think it's an important topic to at least just touch on casually here or in passing a bit. Attempts at tax fraud are certainly on the rise, and we have seen taxpayers become much more brazen about tax fraud. Usually, historically, it had been something that taxpayers may try to send something into the Department of Revenue. If it gets rejected, they would stop there. Increasingly, we've seen taxpayers become much more brazen and start trying to push things into the appeals process and see if they could get some sort of, get one of the levels of appeal to make a mistake and approve their request which effectively a fraudulent request. And so we're seeing a lot more of this come into the tax appeals process. And in fairness, this is across all tax types. This is across all socioeconomic. It can be for small amounts. It can be for big amounts. It can be corporate taxes. It can be personal income taxes. And it can also involve a lot of unscrupulous tax professionals. There have been a number of tax professionals who have been involved in these various areas. Even on a bigger scale, you can certainly think about Ponzi schemes and things of that nature that have been engaged with tax fraud. So we're seeing a lot more percolate through the appeals process. And certainly you don't want to, nobody from the legislature wants to get tied into some sort of situation where they had, inadvertently tried to forward or support somebody who is effectively, trying to make a fraudulent argument in the appeals process. That being said, we very much want you to advocate for your constituents and give them the service that they deserve. I would just say, keep an open mind and the old adage that, sometimes if something sounds a bit too good to be true, maybe it might not be true. With the advent of artificial intelligence, there's some both fascinating and scary things we see on fraudulent document creation, things like that. So there's a lot going on in this area, and so I don't want to scare you too much on this. I want you to advocate for your constituents. I just also want you to keep an open mind to the notion that sometimes if things sound too good to be true, they may unfortunately not be true. So final slide here, some tips for success, which is a little bit of just a rehash of the content here. One, if I didn't scare you on that jurisdictional slide, I'll take one more shot at it. Do not miss the appeal deadline. There are lots of complications that occur when a taxpayer misses an appeal deadline, including that provision that if they want to access their due process rights, they may need to pay the full amount of the assessment to then request a refund back. That's always a difficult pill for taxpayers to swallow. So it comes back to the notion, do not play with those deadlines. Encourage the taxpayers to get them in as early as they can, because missing the appeal deadline causes significant problems. Make sure the taxpayer states the relief requested in the petition. This is actually happens more commonly than you'd expect. Taxpayers will give us a long recitation of everything that's happened and every phone call they may have had with the department or calls they had with their CPA, all this kind of stuff like that. And then they forget at the end of the day to tell us what they want. In some ways, it's sort of a help us, help you type thing, and make sure that the taxpayers are clearly stating what relief they want. I think I'm entitled to X amount of property tax rent rebate, or I think I'm entitled to a certain amount of unreimbursed business expenses on my personal income tax return, but clearly state the relief. If I haven't emphasized enough already, obviously the preferred method for filing is through the online petition center. It's better for us and allows us to process appeals faster. It's better for the legislative office. It gives you more tools, more certainty, and at the end of the day, it's just a better process, a more secure, safe process for the taxpayers, and that's really what we're getting at. That's this filing using the online petition center is going to be better for your constituents. That being said, if for some reason you do send in something via mail, I would encourage you to have clear proof of mailing. I also make note that private meter stamps, your Pitney Bowes, your stamps.com, those are not accepted as proof of mailing. A lot of those are basically the equivalent of buying postage. So it's like you go to the Hallmark store and you know buy some stamps at the Hallmark store. That's the date you bought the postage. That's not the date that you necessarily sent anything in via mail. So those type of private meter stamps are not acceptable as proof of mailing. I also like to make note that contact with the department, and in the case of the legislative offices, it may be oftentimes contact with our legislative office. The contact with the department does not toll that time limitation to file the appeal. Once that notice of assessment that I talked about at the beginning is sent out, and that 60 days or 90 days as it may be starts running, just simply talking with the department, sending an email into the department, things like that, that does not stop that time frame from running. If you happen to be filing, this is for my sales tax colleagues, if you happen to be filing a sales tax appeal or assisting with the filing of a sales tax appeal, make sure to include the REV 39. This is basically a form that identifies the transactions. You can't just come in and say, I want $5,000 of sales tax back. You need to identify the specific transactions that you think were inappropriately charged sales tax, and request the refund, and identify those specific transactions. Obviously, you're going to want to make sure that you obtain all necessary signatures. This is going to be, it could be electronic with the taxpayer. It could be, on the paper form as well. And obviously, with the legislative offices, you're going to, if you want us to be able to discuss things with you, you're going to want to have that confidentiality waiver. I'll reiterate the notion that in this context of tax appeals and moving through the judicial system, the term representative means tax professional, like a tax attorney or a CPA. This does not mean an elected representative of the General Assembly. So that's an important distinction that I hope I've clarified, and we certainly have that specific section of the Board of Appeals online petition center specifically for legislative staff and constituent services purposes. We touched a little bit earlier on the hearings, and so the taxpayer will want to affirmatively request a hearing at either level. As I mentioned, the majority of our cases are decided without a hearing, but we're certainly happy to accommodate taxpayers if they do want that opportunity to be heard. And the last thing I'll touch on here is that clarify a little bit of a technical point. An amended return is not the equivalent of filing an appeal. If there are any lawyers on the call, which I imagine there may be, Quest Diagnostics versus Commonwealth is the lead case in this area that has made very clear that filing an amended return is a courtesy provided by the department. Oftentimes, amended returns are effective vehicles for clarifying simple errors or correcting, certain mistakes. But at the end of the day, the legal right to adjust something comes as a petition for refund. So it's important that your constituents know that the filing of an amended return is not the same as filing an appeal with the Board of Appeals. Also, you cannot file an amended return to fix an assessment. If you want to fix an assessment, you need to file that appeal with the Board of Appeals. There's even a specific section on the Board of Appeals website that specifically addresses this point. So with that being said, we've covered an awful lot of ground here. I hope I didn't go too fast. I hope it was informative. At the end of the day, we certainly, I'll come back to sort of that bumper sticker notion here to wrap up. We are certainly aiming to resolve tax appeals accurately and efficiently at the lowest level possible. But we always appreciate feedback and thoughts if there are things that we can do for it. We're very much a continuous improvement focus here. And so we will happily welcome thoughts and feedback from the legislature as to how we can continue to improve our operations. I thank you for your time, and I'll stop here with regard to the content, and I'll see if there were any questions that may have popped up.